Welcome, welcome, welcome. This is section 6.3 of Introduction to Criminal Justice, and this is where we talk about court cases that have had a dramatic impact on how police officers do their job. There are going to be a lot of these, but these are very easy to create test questions from. Hint, hint, nudge, nudge. So you should probably know each of these cases and what makes them important. Okay? So, prior to 1914, we had all these rights guaranteed by the U.S. Constitution, right? But there were very few or no penalties that law enforcement agencies would face if they violated those rights, right? So let's say prior to 1914, a police officer does a search of you that did not have a warrant, did not have consent, violated your rights in your search, found some evidence. They were still able to take that evidence and use it against you in court. And when the judge said, hey, you violated their Fourth Amendment rights to gain that evidence, the police officer would be like, oh, yeah, sorry, shouldn't have done that. And there was really no repercussion for the case, right? But 1914, Weeks versus United States, there was a federal police agent that violated somebody's Fourth Amendment rights, searched them in a way that was unconstitutional, and it went all the way to the Supreme Court, and the Supreme Court said, look, if you violate someone's Fourth Amendment rights in order to gain some kind of evidence, you then cannot use that evidence against them in court. Okay? That's the punishment for violating the Fourth Amendment. If you do a search without a warrant, any evidence you find, the judges, from now on, we're going to toss it out. You cannot use that against them in court. That means that, now there's an actual thing that police officers have to be worried about, right? So now if I search this person and I do it wrong, it's going to totally screw up the case. I better make sure I have that warrant, or I better make sure that exception is a really important one, whatever. But this only applied to federal law enforcement. Okay? Earlier section I talked about the incorporation clause of the 14th Amendment. 1914, Weeks versus United States, this whole exclusionary rule thing only applied to federal law enforcement or the federal government. State law enforcement, local law enforcement, were still perfectly able to violate your Fourth Amendment rights, do whatever kind of searches they want, and there was no punishment for that. This only applied to the federal government. So this resulted in what's called the Silver Platter Doctrine, right? Where a federal police officer would violate someone's rights, find some evidence, and be like, okay, I can't take this case further because the judge is going to toss it out. So he calls up a local or a state police officer and gives them the case on a silver platter. He says, here's all this evidence, here's the bad guy, here's what I found, here's all this, here's all this. Then the state or local guy would take it, arrest the bad guy, take it to court, and win, because the exclusionary rule didn't apply. Doesn't matter if that evidence was gained through violation of the Fourth Amendment. Okay? Next case, 1918. Okay? Very, very similar case to the first one, except instead of violating someone's rights, found evidence, tried to use that evidence against them in court, in this case, it was police violated someone's rights, found some evidence, used that evidence to find a second piece of evidence. Now, the exclusionary rule only applied to that first piece of evidence, right? Because that was the thing that they found during the violation of the rights. They didn't violate anybody's rights in order to find that second piece of evidence. So thus, the second piece of evidence between 1914 and 1918 was still admissible. 1918, Supreme Court says, no, that doesn't work either. Anything you found not only during that search that violated their Fourth Amendment rights, but anything you found because of the evidence you found in that violation of their rights is now no longer admissible, right? So if you find if a violation of violation of their rights results in evidence A leads to evidence B leads to evidence C. It's not just A that we're going to toss out, it's anything in that entire tree of evidence. We're going to toss out A and B and C, right? It's called the fruit of the poisonous tree doctrine. If the beginning of that evidence chain was a result of a search that violated their rights, not only are you tossing out that evidence, you're tossing out now any evidence you found because of that evidence. Make sense? All right, but still, this only applies to the federal government. 1925, there's this thing called the Carroll Doctrine, because it was a court case, Carroll v. U.S. or Carroll v. somebody. And that was all about the search of vehicles, right? 1925, the Model T is out. There are all these cars, and police really need to know about what they're allowed to search and what they're not allowed to search. And essentially, the Carroll Doctrine was about how much privacy you could expect in a car. And essentially, the short version is you have less of a privacy expectation on a public road than you do in, say, your house or your business or, on your private property. Because the roads you use are public and because you must be licensed by the state to drive that car, there is a state interest in making sure you're not doing something illegal in that car. Thus, you still have Fourth Amendment rights, they're just different. They're lesser on a public road in a car than they are in other places. Okay. 1928, Olmstead v. U.S. There was a bootlegger. He actually happened to be a police officer himself, and he was a bootlegger. He was running illegal liquor, and telephones were becoming a thing. So the police agencies wanted to tap his phone. So they went down the street and they literally tapped into the phone wire that came out of his house and into the public, onto the public telephone system. And they added a little splice and they listened to all his phone calls. And because of that, they didn't have a warrant to do that, right? Now, this goes to the Supreme Court, and Olmstead says, hey, they violated my Fourth Amendment rights. They searched my telephone calls without a warrant. You need to toss out this evidence based on the exclusionary rule, right? The Supreme Court says, no. They didn't touch you. They didn't touch your person. They didn't touch your papers. They didn't touch any of your effects. All they did was touch the telephone wire, right? And that's not owned by you. That's a public utility. Thus, not a Fourth Amendment violation. Evidence stands. And this was how the Fourth Amendment was interpreted for about the next 40 years. And we'll talk about how this got mostly overturned in a few minutes. 1936, Brown v. Mississippi, you can no longer have forced confessions, right? So in an earlier section, I talked about how police can't force confessions. They can't have the threat of force. They can't have actual force. They can't do certain things to induce you to confess. They can't threaten your family. They can't do any of that stuff. So prior to 1936, they weren't allowed to do that, but their confessions would still be introduced into evidence. Now, Brown v. Mississippi, not only can you not do it, but you're not allowed to use those confessions at all. If it was found that you forced that confession, we're going to toss it out. No longer admissible in court, right? 1949, Wolf v. Colorado. This is an incredibly important case. Because for the first time, that whole exclusionary rule, fruit of the poisonous tree, all that stuff that I talked about up on the list there, no longer, after 1949, no longer only applies to the federal government. After 1949, not only can the federal government not violate those rights, not only does the exclusionary rule apply to any evidence gained if a federal agent violates your Fourth Amendment rights, now the exclusionary rule, fruit of the poisonous tree, whole 9 yards, also applies when any state or local police officer violates your Fourth Amendment rights. They used the 14th Amendment to incorporate, essentially, the Fourth Amendment, or at least part of the Fourth Amendment, and say, look, This Fourth Amendment, the Due Process Clause, means that not only does it protect you from the federal government, but it protects you from government. Doesn't matter whether we're talking the federal government, the state government, local government, whatever. It protects you, right? So after 1949, any kind of law enforcement agent that violates your Fourth Amendment rights, that evidence gets tossed, okay? 1963, very important case. Gideon V Wainwright, okay? This guy Gideon gets arrested. He's poor, can't afford a lawyer, puts up a terrible defense, gets sent to prison, appeals to the Supreme Court, says, look, I didn't have a lawyer. I didn't know what my rights were. I didn't have a lawyer. I didn't have anybody to defend me. And now I'm facing, this huge prison sentence, all because I'm poor. And the Supreme Court says, you know what? You're right. This is America. We need to make sure that everybody's taken care of. We need to make sure that everybody's rights are respected, even if they're poor. So from now on, anybody who can't afford a lawyer will have one appointed to them free of charge. Whatever level of government is trying you is responsible for making sure that you have a lawyer, even if you can't afford one. Okay? That was an incredible benefit for the poor people in this country. 1966, Miranda v. Arizona. We talked about this one already, but it's a very, very important case. Anybody who's arrested, anybody who's suspected of a crime, anybody who's interrogated by the police have a right to know what their rights are, right? So the police, every time they arrest somebody, every time they're going to interrogate somebody, every time they're going to go in and treat you like a suspect, they are legally required to tell you what your rights are. And we all know those Miranda rights. We've all heard them a million times because hopefully we all watch Cops, because Cops is a great TV show. I love that show. 1967, Katz v. U.S. This is one of the most important court cases in U.S. history. Okay? Katz was a bookie. He took sports bets, right? And he would go to a payphone. There were 3 different payphones that he would use, and he would call and he would place bets using these payphones. $50 on, the Cubs to win or whatever. Now, remember, we talked about Olmstead v. U.S., and in Olmstead it just said, did you touch their person, their place, their effect, anything like that? No? Well, then it wasn't a search according to the Fourth Amendment. So this is how, between 1928 and 1967, that's how law enforcement acted. If they're not touching you or your property or your house or your things, it doesn't count as a search, thus we don't need a warrant. Katz changed this. Okay, so what happened was there were these phone booths, and the FBI suspected Katz of doing these illegal bets. So they put a recording device in the phone booths. Funny story, they only had 2 recording devices, and there were 3 phone booths. So what are they going to do? They call the phone company and they say, hey, these 3 phone booths, we need you to take one of them out of order so we can put these 2 recording devices in the other 2 phone booths. And the phone company says, no, we're not going to do that. That's stupid. And the FBI says, all right, we've got an FBI agent here with a sledgehammer. One of those 3 phone booths is going out of order. You can take it out of order, or we can put it out of order. Your call. So the phone booth took one of the 3 out of order. FBI put recording devices in the other 2. Then they sat around and they waited. And of course, Katz comes in, uses the phone booth, importantly, closes the door. Because this is back in the day when the phone booths were like enclosed booths. They had doors. So he closes the door, calls up whoever, places his bet. FBI is recording it using the recording device. They use that recording against him in court. Katz says, wait a minute, that's a violation of my Fourth Amendment rights. Goes all the way up to the Supreme Court. Supreme Court says, you know what? You're right. Under the Olmstead ruling, this would not be a violation of your rights. But you're right, that was. So we're going to overturn Olmstead, and we're going to say that the Fourth Amendment doesn't just apply to your person, papers, and effects in the physical sense. The Fourth Amendment applies anytime anybody has a reasonable expectation of privacy. And that has essentially been the philosophy ever since. Anytime that any person has a reasonable expectation of privacy, the police require a Fourth Amendment or a warrant to make sure they abide by the Fourth Amendment. If there is no reasonable expectation of privacy, if I'm standing out in the middle of a public street and I'm talking on a cell phone, I have no reasonable expectation of privacy that my words won't be overheard. Thus, the police don't need a warrant to record me, right? I have no reasonable expectation that my words are going to remain private. Because Katz closed the door to the phone booth, the court ruled that he had a reasonable expectation of privacy. He believed that that phone call was just between him and the person he was calling, and that was a reasonable belief. Thus, the police needed a warrant before they made that recording. Okay? And that is essentially what is still happening today. If any time any person has a reasonable expectation of privacy, police need a warrant. Okay? Make sense? Good. That's an important case. 1968, Terry v. Ohio. This is where the Supreme Court essentially rules that police, even if they just have a low standard like reasonable suspicion, they can stop somebody in public and pat them down on the outside of their clothes for weapons, for reasons of officer safety, right? So if a police officer sees you and he has reasonable suspicion, whatever, he can pull you over and say, hey, I'm going to pat you down for weapons, and then pat the person down. And at that point, plain touch applies, right? So if you have drugs or something on you and they're patting you down for weapons, they can still find those drugs, plain touch. But those stops, they're called Terry stops now, okay? So ever since 1968, the police have had that legal ability. If they have some reasonable suspicion, they are allowed to pat down on the outside of the clothing anybody they want, as long as they have that reasonable suspicion. 1985, Tennessee versus Garner, another big one, okay? Prior to 1985, police officers were allowed to shoot, essentially if they had probable cause to believe you were either in the process of committing or had just committed a felony and you ran away, police could shoot you, right? They could shoot you in the back if they had a reasonable belief that you had just committed a felony or were in the process of committing a felony, right? They roll up on a burglary, you run away from the scene. Well, burglary is a felony, you're running away, I can shoot at you, right? 1985, Tennessee versus Garner, Supreme Court finally says, no, that is absolutely ridiculous. You cannot shoot somebody if they're fleeing. And essentially, there's another court case, Connor v. Graham v. Connor, that essentially spelled it out a little bit more. But essentially now, 2018, if police officers want to use deadly force, essentially the rule is police are only allowed to use deadly force if the officer themselves or some other innocent third party is in imminent threat of death or great bodily injury. Very similar to the self-defense thing we were talking about before. So police are only allowed to use their gun if they or some other innocent third party is in imminent threat of death or great bodily injury, right? And if somebody's running away, he can't be an imminent threat to anybody, right? But if they pull out a gun and they're pointing it at the police officer or at some other person, that's an imminent threat of death or great bodily injury. If they're driving right towards the police officer and the police officer reasonably believes they're not going to stop, like the person is going to hit the officer with the car, that is an imminent threat of death or great bodily injury, right? But that's essentially where the standard is now. 2004, Hibble v. 6th District. This court case essentially says you do not have the right to remain silent when it comes to identifying yourself. So if the police have reason to ask you your name, you cannot plead the fifth and to not give them your name, right? You can be legally required to identify yourself. First name, last name, obviously the easiest way to do this is a driver's license or some other kind of identity card. but the police are allowed to take that to any level that they need to in order for them to be satisfied that they know who you are. Okay? You have to give your name. You cannot plead the fifth when it comes to identifying yourself to the police. Make sense? Good. 2006, Hudson v. Michigan. This was a court case about the no-knock warrants. Okay? Essentially, prior to 2006, it wasn't very clear whether police were required to knock and announce their presence before serving a search warrant or an arrest warrant or whatever. So let's say I have a search warrant or arrest warrant, whatever, Bob Smith's house at 1234 Main Street. Prior to 2006, it wasn't clear whether I had to, some areas said I had to, some areas said I didn't have to, show up, knock on the door, say, Bob Smith, this is the police, come to the door, you know, we're here to arrest you, we have a warrant. Then wait for a minute, give him a reasonable amount of time to come to the door and open it. And if he doesn't, then I have the right to go in, you know, with a battering ram or break the door down or whatever. But there were some areas, some lower level courts that ruled that you have to do that. Okay? Other areas said, look, a judge can give a special warrant called a no-knock warrant, where you don't have to wait that reasonable amount of time before going in. You're allowed to just show up, knock the door down, say, police, 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 we're coming in, we have a warrant, right? You don't have to wait for them to come to the door. You still have to announce your presence. You still have to say, we're the police, we're coming in, we have a warrant, blah, blah, blah. But you don't have to wait, because the fear is, if you wait, the police are afraid the person is either A, destroying evidence, or B, they're, you know, getting their gun and loading it and pointing it at the door, waiting for the police to come through, right? So in certain cases, some areas prior to 2006 said you can get this special no-knock warrant. Other areas said, no, you can't get that special no-knock warrant. 2006, Supreme Court finally put a rest to it, said, all right, you are allowed to do that. If a judge specifically signs a no-knock warrant, you're allowed to do that. You don't have to wait for them to come to the door. If there's some reason to believe that they're either going to destroy evidence or they're going to set up a defensive thing and grab their gun and point it at the police officers, in those special cases, if the judge agrees, you can get this special warrant that says you can just show up, batter the door down, announce your presence, and go in. You don't have to wait. Okay? So those no-knock warrants are legal across the entire country if the judge gives that special permission to the warrant. Good? Good. Last couple, I promise. 2010, Burgess v. Tompkins. Okay? Essentially in this case, guy gets arrested, chooses to remain silent, but doesn't say, I am choosing to remain silent. Right? He just doesn't say a word about anything. Cops put him in an interrogation room, proceed to question him for like 10 hours or 12 hours or something ridiculous. Finally, after all this time, guy breaks down. He's exhausted. He's hungry. He's been broken down over this hours and hours and hours of questioning. Finally starts talking, right? Appeals, goes all the way to Supreme Court. The guy's argument is, look, I was choosing to remain silent, and they continued to question me. What the heck? Why didn't they have to stop questioning me when I chose to remain silent? Supreme Court ruled that you have to indicate you are choosing to remain silent. You can't just remain silent. You have to say to the officers, you have to make it explicit, I am choosing to use my Fifth Amendment right to remain silent. I want a lawyer. I am not going to answer your questions. Until you positively say that, until you positively indicate somehow that you are exercising your right to remain silent, police officers can interrogate you all they want. Make sense? Good. And then finally, 2012, U.S. v. Antoine Jones. This was a case where Antoine Jones was a suspected drug dealer, or gang member or something, and the government put a tracking device on his car. And now, you know, his car, again, public roads, right? So we don't need a warrant. Public roads. We're not tracking them anywhere other than, you know, public. Thus, he has no reasonable expectation of privacy in where he goes. If we legally wanted to, we could have somebody tail him. We could have a police officer like drive behind him. But we're going to do this the easy way with technology and just attach a GPS device to their car, and then we can track them all over the city. Antoine Jones was convicted based on this GPS data. Appeals goes all the way up to the Supreme Court. The law enforcement's argument is no reasonable expectation of privacy. He was in public the whole time. We didn't track him, inside his house or anything. It was just, and again, if we had wanted to, we could have put a police officer in an unmarked car to follow his car wherever he happened to drive. What's the problem? Why do we need a warrant for this? It was public. But the Supreme Court ruled no. Not only is it the whole reasonable expectation of privacy from Katz v. U.S., but it's also the whole Olmstead thing. You touched his car. You attached a device to his car. That is an intrusion. That is a search of a person, paper, or effect. His car was his effect. You touched it. Thus, that is a search. It violated his Fourth Amendment. It's not just Katz. It's not just the reasonable expectation of privacy thing. It is also that Olmstead can't touch their stuff thing. Okay? So if you want to attach a GPS device to someone's car, you have to get a warrant first because you're touching his car. Make sense? All right. That's the end of Section 6. We'll be back with Section 7. Thank you for watching.